Hi, I'm Kelly, and this is my assistant Kelsey. We have, our office is located right down the street on 4th Avenue. Welcome to Devil's Lake. This is our group, our staff. I am originally from Devil's Lake, or my parents grew up in Matcham, North Dakota, and moved here to Devil's Lake. My dad managed the case dealership in Devil's Lake, and now is the owner of High Plains Equipment. I graduated from Devil's Lake High School and went to UND for art, and then panicked and went to law school. I didn't know what I was going to do with an art degree or how I was supposed to make money with that. So I finished law school and moved to the Twin Cities for a number of years. And my dad kept saying, Kelly, there's opportunity in North Dakota. And that's all he would say. And so eventually I could see that there was a huge need in this community for professional services so that our local farmers didn't need to go to Minneapolis or Bismarck or Fargo to discuss what their plans were for succession planning for their farm. It's been really great to be back in Devil's Lake and to have the input and help from my parents when talking about farm succession planning and what they've seen in the last 50 years. So I opened my firm in Devil's Lake in 2014, and we've grown. So it's not just me. We have Haley, who is our admin assistant and does all of our intake. So if you call our office, I just have to let you know that, or you call or walk in, you're not generally going to be able to just come and sit down and talk with me without first having an appointment and going through a conflict check. And that's what Haley does for us. Gretchen is one of our paralegals, and so she does a lot of collection of documents and following up with our clients to make sure that we have everything that we need to do the best work that we can. Holly has actually moved on to Denver, from Denver since I made the slideshow. We'll miss Holly, but Kelsey, who is right here, Kelsey is our firm administrator. So she generally assists Haley with intake, and then we'll sit in on most of our estate planning meetings with clients. She helps me with the drafting and also helps our clients with scheduling appointments and making sure that we don't lose touch, because my experience working with farm families is that it takes them a while to come in and speak to a lawyer, and we maybe have a meeting or two and then they want to think about things. And sometimes it can be a year or 5 years later before they come back in to do anything. And then we start over again. So Kelsey is very good at following up with our clients and making sure that we're following the pace that they want to follow. Heather is an attorney that works with us. She's licensed in Texas and Colorado, and she's working on her licensure here in North Dakota. And that's me. So what are we here for today? I want you to interrupt me with any questions that come up. If you have something that's just been nagging that you have wanted to ask an attorney and you're not shy about doing that in front of an audience, please do that. I feel like that's how these discussions work best, because your question is something that somebody else has been thinking about as well, and they may be able to elaborate on that. One of the first questions that most clients say to us when they come in to do estate planning is, what happens if I go into a nursing home? And so understanding that that is a large concern, especially for families whose major assets in their farm business is land that's generally titled in their personal names rather than an entity that would be protected. Medicaid becomes, and the Medicaid application process and asset determination ends up being a huge concern for a lot of our farm clients. We'll also go over what documents are generally included in an estate plan. A lot of our clients will say, well, I already have a will. I don't think I need anything else. And I will let you know that a will, while that is important, usually a power of attorney or a medical directive ends up being something that is more emergent. If there was ever a health emergency or somebody had an accident or maybe was having competency issues, having to go to a court and have a guardian or conservator appointed for someone to make business and financial decisions is a very expensive and time-consuming process. And it can be stressful. And if you can meet with somebody and put down who you want to be your power of attorney and do that in writing, you can avoid thousands of dollars of attorneys and court fees and probably a 9-month process. I'll just use this one. Can you hear? No. Oh. All right. Maybe this one's louder anyway. Okay. So we'll talk about what all the different documents are that we include in our estate plan for our clients. Next, we'll talk about what is a trust versus what is a life estate deed. Because another top question. Okay, another top question that people, when they call in, they say, well, I think we have a trust. And my staff can usually look up the deed records and we'll generally find that there is not a trust, it's a life estate deed. And so I can talk a little bit about what the difference is of a trust versus a life estate and how either of those are set up and why you would choose one over another. And finally, we'll go over how you would get started with our firm or any other law firm on working on creating an estate plan. So there was a post that has shown up and it comes up on Facebook or social media every so often. And it's a list that somebody put together of all the documents that you would ever want to have in your records in case of emergency. And so I know it's hard to read from where you are, but that's brought up a lot of concern from people in the community who've come to us and asked, do you do these documents? And we do. So one of the questions is, do I actually need a will? You don't have to have a will. If you die without a will, anything that you jointly own with a spouse is going to go likely to that spouse. Or if you have bank accounts and you have set up beneficiaries on those bank accounts upon death, then those accounts are going to transfer over to your beneficiaries without having to do a probate. The reason that we suggest having a will is if there's any assets that are in your name only. Also, so that you can name who your personal representative would be. A personal representative is the individual who takes over, kind of steps into your shoes, and they'll handle collection of all of your assets, determination of what your debts are, and then determining how your debts need to be paid off and how your assets will be distributed among your heirs. The reason that I suggest having a will is if you have more than one
if you're married, your spouse has priority of appointment. But if you are single or widowed, and you have more than one child, then it's up to your children to agree on who's going to be your personal representative. And in our experience, that sometimes is the most difficult part of doing a probate, is having all of your children agree. I'm not saying that all families are ready to dispute or argue or fight, just that it can be a timely process to get all of your children together and to discuss and for them to come to an agreement. Whereas if you have decided who your personal representative will be, it makes that portion of opening an estate much more clean. Okay. So as I mentioned before, one of the first questions that our potential or new clients say is, what if I go into a nursing home, or what if my spouse goes into a nursing home? And I'm sure probably most of you have heard that if there is basic care medical needs in a nursing home that is needed, generally the cost in this area is $10,000 to $15,000 a month. And that's full care, not assisted living. But I'm sure you can understand how $15,000 a month over a period of several years can really deplete a farm's assets. And so what we do is when we sit down with clients is we go through, we look at what your assets are and how they're titled. And we determine what assets would you like to protect from a potential bill from the nursing home. And we can do that, but we need to do that 5 years before needing to apply for Medicaid. There's been a lot of questions that people have asked, like, well, I heard it was 7 years, I heard it was 10 years. It used to be 3. Right now, there is a 5-year look back period. So from the date that you apply for Medicaid assistance, the state of North Dakota will look back at all of your bank accounts, assets, transfers of assets, gifts that you have made from 5 years from the time of application. And what they're looking for is to determine whether or not you have gifted any cash, land, or other assets to another party in order to deplete your assets and then qualify for Medicaid. So that's the reason that we want to do some of this planning well in advance of anyone ever needing to go into nursing care.
Yeah. That to be good, 5 years of the fact that you have that home that, let's say you're living in and your spouse or your children that be.
Okay, so the question, correct me if I get this wrong, but you're asking about your personal residence?
Yes.
And if that 5-year look back period includes your personal residence, who your spouse may continue to live at home in.
Your spouse or your child.
Okay, so that is a great question. Your home is an excluded asset. In the event that you have a spouse who is not needing nursing care and is still living at home, then your house is not considered an asset for purposes of qualifying for Medicaid. If you have a child that's living in the home, the only way that it would be an excluded asset for Medicaid would be if that child is like a dependent of yours. So under the age of 18 or has a disability and relies on you for their needs. But even if your spouse is still residing in the home, there's no requirement that the house is sold during your or your spouse's lifetime. But upon your death, there is a lien then that the state of North Dakota will put on the house So that upon your spouse either passing away or selling the house, then the state of North Dakota can be reimbursed for any expenses they paid for your medical care. So again, it's important to think about some of that and what your plans are. Especially if a farm or your residence is one of your main assets that you're looking to protect and pass on to the next generation. Does anyone else have questions about Medicaid specifically? No? Okay. All right. We can come back to it too. So if you're thinking about it and want, just raise your hand and we'll answer it. So I'm going to go through what some of the basic documents are in an estate plan. Number one is a will. We always want to include a will because, as I mentioned before, we want to name who your personal representative is. We want to name how any assets that you have that is titled in your name only will go to your heirs. We often talk to our farm families about how fair and equal are not the same thing. So if you have a child who has given up other opportunities to stay at home and continue to work on the farm throughout their lifetime, it may not be fair for them to only receive an equal share as their siblings who may have gone off to college and lived in other parts of the world and have more earning power because they didn't stay back home and work on that farm. So we talk a lot, and when I mentioned that sometimes it takes people 5 years to come back in, that's usually why, because they're having a really hard time, especially a husband and wife deciding how they're going to reconcile that. So your will is something that could be one of the tools that would set forth how your farm assets could be distributed amongst yourself and your children or your children. The next document is a very important document, the power of attorney for financial and legal purposes. And this document allows, while you're alive, someone else to step into your shoes as your attorney in fact, and that person at that point can sign deeds, they can mortgage land, they can generally work with applying for Medicaid or Social Security, disability or other benefits. Your agent is able to file your tax returns on your behalf, request documents and information on your behalf. And this is a very important document. If anything were to ever happen where you were traveling, maybe living down south for the winter, or having memory or competency issues. When COVID happened, a lot of people came to us and they said, well, my mom or my dad is in the hospital. I don't know where their bank is. We have all these bills coming in. I can't get access to their bank accounts. I can't pay their creditors. I can't do anything. And so having this power of attorney document allows somebody else in your absence to step in and handle some of those things for you. The next document is a medical power of attorney, and that sometimes law offices put them together. So your financial, legal, and medical power of attorney are all one document. What we like to do is allow, there's a lot of families around here who have nurses and daughters, sons, grandchildren, so somebody in their family that works in the medical field. And to them, that makes more sense for that child or grandchild or whomever to make some medical decisions. Or maybe there's somebody in their family that just has a better head for medical decision making, and another child or someone else has a better mind for handling the finances. So we like to have them separate. Your medical power of attorney will allow your medical agent to decide where you should receive care, who your doctor should be. If you're unable to say what your wishes are regarding treatments, your agent is able to authorize treatments based on what they believe your wishes are. The next document is a HIPAA release, which I'm sure every time you've been to a clinic or a hospital, you've had to sign. Our HIPAA release is a blanket release that we usually include all of your family members, so that if you were ever traveling and had a medical emergency, whoever is with you or whoever can get to you the soonest, that will allow the hospital or emergency room to speak openly about what is going on in your condition, so that then they can share that with your family. We're in North Dakota, and so what we found is, I know we're a little bit behind the times, and our hospitals and clinics are a little bit more open about sharing with family members, because it's a small community, we know who everybody is. But I will say that as the years go on, that liability on the clinic or hospital to share that information has increased, so they're not as willing to share. So we just think the worst thing is somebody's having a medical emergency is not to be able to get that information. So that's why we use a HIPAA release. And then the last document is an optional document, but that is a living will. The living will is the document that says that if you had a terminal illness, there is no chance of you making a recovery or living a meaningful life, that you would not want machines to keep you alive. So that would be like artificial nutrition or hydration, maybe invasive surgery. This document allows your medical agent, it tells them that that's what your wish is, because I think a lot of family members have a really hard time making that decision of when it is time to remove some of that artificial hydration and nutrition or respirator. And so this kind of takes that decision and the weight of that decision on your agent's shoulders. Does anyone have questions about what we include in our estate plan documents? All right. So as I had mentioned before, we have a lot of people who call and they say, well, I think we have a trust. And it's very often that there is not a trust. Trusts are a very formal document and generally require accounts to be retitled in the name of a trust. If it's an irrevocable trust, it has its own social security number and it does its own tax return. And so what we generally find is that it's not a trust that a family has in place, but a life estate deed. And so what a life estate deed is, for if I owned land and I wanted to gift that land upon my death to my child, then what I would do is I'd say, I am giving a life estate deed. For my lifetime, it's mine. I pay the taxes. I'm entitled to income. But upon my passing away, all that is needed is a death certificate to be recorded, and then that land will pass to my child without a probate. The other thing is that life estate deed, once it's been signed after 5 years, any land that I've put in that life estate deed is now not considered an asset for Medicaid purposes. Exactly. So as long as it's been in place for 5 years, then that is not a countable asset. It will not disqualify me from Medicaid. It wouldn't be an asset that I would have to sell and then use and spend down on my care before I would qualify for Medicaid. And so we do a lot of life estate deeds when we do people's estate plans. And it just depends on everyone's situation. So that's something that we always talk about. You could put, let's say you had 5 sections of land, and you had 3 children. You could put one section of land in each of the children's names. So you could say, well, I want section 26 to go to child A, I want section 27 to go to child B, I want section 30 to go to child C. And then you can say for the other two sections, I want all of that land to go to them together jointly. So we talk about what the pros and cons are of doing that. A lot of our farm clients have a hard time saying, I want to give this section to this child and this one to this child, because they don't know what we don't know what the value of the property is going to be upon death. Yep.
When you receive a life estate,
Mhm.
I say my mother gives me a life estate, what do I do with that then afterwards?
Okay, so the question is, if you are the recipient of a life estate, what do you do once your parents have passed away? So in order for the title to be changed from their name to yours, you need to record an original death certificate and an affidavit stating that your mom or whoever is the original owner, that they've passed away. So that's generally a pretty simple process. We have people that come in and that's, we draft those. I think we charge $200 to do that. But that way, then the land is now titled in your name. The tax statements come to you. You're now entitled to rental income. That's just kind of, rather than going through the whole probate process, that's how that transfers to you.
So is there any tax implications on that one? Or-
Great question. So the question is there any tax implication with that gift? So the gift for a life estate deed, the transfer doesn't occur until after death of the grantor. So the transfer has a stepped up basis. So the grantee's basis in that property is the date of death value. So no, there is no tax implications. One of the documents that Kelsey handed out, and we have more up here for anyone who came in late. But we have a comparative chart here of what is tax implications for a lifetime gift versus a transfer upon death. And that is one of the largest things. So sometimes people say, well, I just want to give this section of land to my child. And we say, well, I think let's talk about that. Let's walk through that. And what does that look like from a tax standpoint? Because if you inherited that land from your parents or they gifted it to you and they paid $100 an acre, and now the value of it is around $2,000 an acre, then that amount, that's a capital gain basis right there. $1,900, so per acre. So that's a huge tax implication. Sometimes people are like, well, that's okay, because I don't want my child to sell it ever. So I want them to keep it for their life, and this is having that capital gain over as a possibility is going to make it so they're never going to want to sell it. So we talk about that as a potential option as well.
The capital gain isn't done until it's sold.
Right, so there isn't a tax, it isn't taxed until it's sold to a third party by the grantee.
That's not a gift.
Yes, if it's gifted during lifetime. If it's gifted, if it's given through the life estate and upon, so let's say I received land from my mom and she died in, let's say, 2015. I received it and the value was, we'll say, $1,500 an acre. And then I sold it in 2015 for $2,000 an acre. There's still no there's no capital gain, because usually if you sell it within a year or two of death, the IRS will accept the sale as what would be fair market value. But if I held on to the land for 5 years or 9 years now, I suppose, and now the value went from $1,500 of her date of death value to, let's say, $2,000, then I would have to pay capital. If I sold that land, I'd have to pay capital gains on $500 per acre. So if you hold it for a while and it increases in value, then there will be capital gains.
Yes, that's in a life estate deed, or that actually works too if you have inherited land through an estate and probate. So, anytime that you have had land gifted to you after someone has passed away, you get that stepped up basis. And then if you sell it years down the road, that's, so generally your accountant will after someone, or your attorney will let you know after someone's passed away. We need to do an appraisal or at least the market valuation of the value of all the land. So that if it's sold at some later date, we have some documentation to show what the value, what your basis is. So, yeah. Okay, so the question is, if you have a life estate to go to one of your children, and your hope is that after your passing, that your child will not sell that land. Then one of the options maybe is let's do a lifetime transfer rather than so that there's a large amount of capital gains. Or we can put a right of first refusal. So let's say you are going to do a life estate to your son, but before your son can sell it, he needs to check with his siblings to make sure that they wouldn't want to buy it first. And we can even put in there that if they buy it, they get a discount off of fair market value. So we can work out some of those options in a life estate deed, but generally if you're starting to get to the point where you're like, I want this land to continue to be in my family's name. I don't want it to be sold. I'd like my children and grandchildren to have income from it. Then at that point, then that's maybe where we want to talk about a trust instead of a life estate deed. Because a trust has a little bit more, it has protection from your, from creditors of your children or grandchildren. And a trust can't be sold unless a trust, whoever you've decided to be the trustee has determined that that's in the best interest of everybody. Yeah. Okay, so the question is, if you put your land in a life estate deed to your child, or someone, doesn't have to be a child, but if you put a life estate deed granting it to another person, and then you decide before you pass away that you need to sell it, is that possible? And it is possible, but whoever is named as a grantee, they have an interest in the property. So they would have to sign off and agree on that sale. They're also entitled to a percentage of the sale proceeds. So when you determine, or when you're thinking about who you want to give a life estate interest or remainder interest to, you want to know that it's somebody that you feel that you can trust, that they would work with you if that ever came up. Because the life estate deed is an irrevocable transfer. And that's why it qualifies for that 5-year look back period, is because there's somebody else who has an interest that's not you. Yes. Yes. Okay, so the question is, if the person that you're granting that remainder interest in the land to, so you have a life estate deed to a child, and at your death, that child has creditor claims, they have a pending bankruptcy action, maybe they have a pending divorce action. All of those types of claims, yes, are subject to, so your life estate land can be opened up to their claims. Not that it would be sold during your lifetime, but then upon your death, those creditors can walk in and they can force the sale of the property so that they can get paid.
And so if that's something that people come to us and they're kind of concerned about, then that's when we would look at doing an irrevocable trust as a transfer rather than like a estate deed. And I would say that while creditor claims, yes, are an issue, what mostly becomes an issue is having children who are married and being concerned about a potential divorce. Because even while you're still alive, if your child who has a remainder interest has filed for divorce, their spouse, soon to be ex-spouse, can claim their part of their future interest in that land. So if that's ever a concern, we talk about that with our clients and say, is this something that is concerning to you? Maybe you're not concerned about it. So then we'll look at maybe a trust is a better idea than a life estate deed. Another way that we work around that sometimes is we say, so if you have more than one child that you want that land to go to, we say, let's say you have 3 children. We're gonna say, well, you're gonna give your life estate interest to your 3 children as joint tenants with right of survivorship. So that upon your death, it goes to whichever of your 3 children have survived you. That diminishes any of your single children, like any of your children's their individual interest valuation is diminished because we don't know that that child is gonna survive their siblings. And also, and so they could maybe have no interest. So that's another way that you can work around that if you don't want to go through the formality of having an irrevocable trust. And so,
What are the negatives of irrevocable trust then?
what are the negatives of an irrevocable trust? So in order for it to be considered an irrevocable trust, you no longer get to, as the owner of the land, you don't get to be the trustee of your own trust. You have to choose either a farm management program, a trust department from a bank, a CPA or an attorney or somebody who is independent of you. And that person makes your decisions regarding your land. And we explain all of them with all of our clients. And I would say that probably like maybe 2% of our clients decide that it's worth it and they want to go through with the irrevocable trust. It's just so hard, I think, for our North Dakota farmers to give up that control. They want to, and it kind of complicates sometimes the farm programs because then the land is in a trust. It has its own tax ID number. It just kind of makes some of that a little bit more complicated. It has to do its own tax return every year and then issue K-1s to everybody. So it's just a little bit more administrative work and expense. So I think irrevocable trusts are great. But only for people who are prepared for following through with the formalities of it. Because I would never want to set somebody up for failure. Or I think sometimes attorneys are pushed to just do an irrevocable trust and then put a child as a trustee. And while we can do that, that trust could be litigated and found that it was not actually an irrevocable trust and that then all that work that had been done is for nothing. So, yeah.
There's a difference between your revocable trust and the revocable.
Yes, okay. You guys are good. What is the difference between an irrevocable trust and a revocable trust? And a revocable trust means you can put things in and you can take things out. And whoever's created it is the trustee of that trust. So if you create a revocable trust, you have full, it's like you have a trust there and it's its own account, but you can put things in, you can take it out. So the con of that is that there's no 5-year look back period protection for Medicaid. Because anything that you have control over that is not an irrevocable transfer is not protected from Medicaid asset consideration or having to be spent down. A revocable trust and a life estate deed
have both that 5-year look back period protection for Medicaid. So sometimes you have clients and they say, well, I have long-term care insurance that will cover the first 5 years of nursing care. And so, and I've been paying into this long-term care plan, or I have universal life insurance that can pay for my first 5 years. If that's the case, then a revocable trust might be, that's feasible and doable. But if people don't have any other type of sort of plan to pay for at least 5 years of care, then we want to do either a life estate to protect the farmland or an irrevocable trust. So an irrevocable trust is you're giving up all control and management to another third party, and usually a professional. So you're going to be paid professional management fees with that. Whereas a revocable trust is you're the trustee, you manage it. The reason that a lot of people do revocable trusts is that it avoids the probate process. But I will tell you that North Dakota probate is simple and it's inexpensive. The filing fee to open up a probate in North Dakota is $80 right now. There's forms to open up a probate that are free for your use on the North Dakota court site. And it's usually from the time that you submit your application and other proposed documents for probate, the judge will sign off within a week. So it's not a complicated process. But let's say you were in California. California's probate process is, from what I hear, a disaster and can take many, many years. And so in California, almost everybody who is a resident of California or owns land in California has a revocable trust just for the purposes of avoiding probate. The only times that we really want have people use a revocable trust is if they are, let's say, a bachelor farmer or a widow, and they maybe in their family history have some memory or competency issues. What I like to do then is just we'll put it in a revocable trust and name who the successor trustee is. So then whenever that person, as they're getting older, just doesn't want to handle their finances or management of land, their trustee can step in right away and do that. And then upon the person passing away, it's just a very smooth process. There's no probate. The successor trustee just takes over and manages everything. So there's no court involvement and there's a little bit more privacy. So because there's no court filings or anything like that. So does anyone have any other questions about trusts or? Yep.
Why are people going to South Dakota to do a trust?
Oh, why are people going to South Dakota to do a trust? South Dakota has some of the best protection for trust privacy. So South Dakota is is the only state in the US that has decided that their state laws are going to provide very high privacy rights. So you can actually, if you have a trust in South Dakota, the laws in South Dakota they make it so that even your spouse can't find out what you have in your trust. Your creditors can't determine what's in that South Dakota trust. So a lot of time that people do put anything in a South Dakota trust, or they move like a North Dakota trust to South Dakota, is to protect the trust assets from either creditor claims or spousal claims or just privacy.
So there are tax advantage.
There may be, and I'm not licensed in South Dakota, but I think that what their tax rate is from a state, like state income tax or maybe less. But North Dakota, first of all, doesn't have an estate tax. And it's mostly the federal tax on trust is a pretty high, like that's one of the highest rates. So any assets and I'm not a tax professional. I usually let our accountants answer those questions, but any income that remains in a trust at the end of the year is taxed at I feel like it's a 30 or 40% rate. So you want to disperse
any trust assets before the end of the calendar year. And then that goes out as a K1 that flows to and is taxed at each of the beneficiaries' rates instead of the trust tax rate.
And disperse some of the income to yourself.
Yes, so when you disperse at the end of the year, if you leave all the money in the trust, then the trust is taxed at whatever the applicable rate is. But if you disperse it out to everybody, then they just pay, they get a K1 and then they pay the taxes based on what their personal rate is, yes. Yeah. So, and normally I like to have a CPA here to answer those questions, but that's my experience and what I hear from answers. Any other questions about? Let's see. Okay, well, I guess we're just to questions, but so what we do have, and I handed out to everybody, is a worksheet. We have more up here. We have a worksheet that's specific for either married couples or individuals. And if you want to use it and just put it in with your important documents, that's great. Because what this does is it kind of gives a snapshot of where you are, who your family members are, what their birth dates are, who your professional advisors are, what your assets are. So that if something happened to you, where you were unable to provide that information to a spouse or a child or someone else, somebody needed to step in and start managing it. Having this is like an invaluable tool. We've had so many people who have passed away and their family come in and they say, I don't know where their accounts are. I don't know if they have, I don't know if they have IRAs. I don't know where anything is. And if they've filled out something like this and they have brought it in and we just even scanned it and never did anything else, at least we have this so that they have somewhere to start from. What I also tell people is that probates we usually give a year because right now in January is where people are going to start receiving like their 1099s and other tax forms and statements of income for the year. And that is a huge clue to us if someone's passed away to try and figure out where their assets are. So, but if you had filled this out, we know where your accounts are, what your account numbers are. We know who to notify of death. And so that is just a huge tool. And just, I think one of the greatest gifts that you can give to your family in case something ever happened to you. How are we doing on time? Okay. So, I mean, I'm here you guys can ask whatever free legal advice, so, yeah.
I'm a financial advisor. I find it very important for people to have their asset, whatever statement you get from financial institution, on stocks or bond, or whatever it is, get a binder. It only costs more than $10 to put it in, and just put it all in that binder. Make it a lot easier. Because, I have some people who passed away and we don't have their statements. You really cannot go and say, well, I need to pass this one, find out what he has in his account. It's like that. I don't know, a copy at least of that statement that they received from the company. So if you can get a binder, $10, $15 binder, just get it there, put it in.
Hard copy.
A hard
copy, yeah.
Yes.
Yeah.
Well, the thing is with putting everything in the cloud or wherever else is once you're gone, your password's left with you. And so, yes.
Oh, if you put it on a soft copy, just put it in the
Yeah.
normal stick.
Our firm for all of our clients, if anybody ever comes in, they're like, can you just keep a copy of this? We scan it. And we do keep it in the cloud. We have a secure server that we use. But then at least if something happens to you and we know that that is somebody you've authorized to request information, then we can release that and we can help them. You have a question?
As a personal representative, does he have to with all of the person's assets? The investment, If someone wants a piece of the assets for their name because of a child
Okay,
of the deceased,
so
grandchild.
the question is, does the personal representative have a duty to gather all of the assets? And then before distributing them out, they have to have all of the assets.
Well, it has to get all the assets. Let's say the grandchild wants a little pickup, but we. Can you keep that out? And keep it?
So generally,
You have to have it all.
no,
Registry.
what we do is if that grandchild or if all the other children agree that we're going to let this grandchild have like a $500 value pickup, we have them, they're a minor. So then we generally will put that in, title it in the name of a parent or somebody, a guardian with that child's name. But yes, you can do a partial distribution. We have everybody sign a form that says that if a creditor claim came back that we were unaware of and that the estate owed it, then that grandchild would give back or buy that asset from the estate in order for a later creditor claim to be paid. But we do partial distributions all the time because somebody passes away and we know it's gonna be like 2 years to gather all their assets, figure out what their debts are, do all of that. Well, we have a general idea that they're going to have sufficient assets to make a partial distribution, then we will make an earlier distribution to their heirs. However, they've decided in their will. But a lot of times too, people have beneficiaries already named. On your title for vehicles, you can put another owner, a joint owner on a vehicle. So we talk a lot about that with our clients too, like if you,
Passed away unexpectedly.
yeah, okay,
He was young,
yeah,
and he had young children,
okay.
and he was divorced.
Mhm. And no will or anything.
No.
And so then this ex-spouse is probably the guardian of those children. But any, like a family friend could even be the joint owner of that with the child.
Okay, let's see.
So like, let's say you were a friend of that grandchild and you were willing to take on that liability because you're gonna wanna make sure that that vehicle is registered and insured. And that if that child is not old enough to drive, that it's secured somewhere until they're old enough to be able to drive it. But then, so you're agreeing to take that responsibility and you can generally go to the state for personal representative and you can say, I'm willing to do this, and then they can work it out.
I am personally.
You are the person, okay. So if you could do it as a personal representative, or you could select somebody else that you feel would be responsible to go for that grandchild. Yeah.
Roughly, on average, what does it cost to have you?
In the state. So we start out and, we don't bill hourly because I want people to take the time and I want them to think about what they want. And ask all the questions and not feel like they have a clock ticking in the background. And so we do, single, so individual estate funds is $1,000. And that includes all those 5 documents. And then we have, it's $1,500 for a married couple. And that includes those 5 documents. But then if we're going to need to do, let's say, revocable or irrevocable trust or life estate deeds, then we charge extra for that. And we generally charge $200 a deed. Plus a $20 recording. So. And then we'll meet with you, we'll go through all the questions, we'll make sure those questions are addressed. We'll have a draft set of documents for someone. They come in and I go through all of the documents with them and explain. We make corrections at that time and then they sign. And then if somebody comes back like a month later and they say, you know what, I don't feel right about that being my personal representative. Can I make a change? We do that. We don't charge for it. We haven't signed any set of documents. If 3 years go by, somebody's like, I'm ready to re-look at my estate fund, then we usually charge from a beginning basis again, because we want to start the whole process over. If we make a mistake and you find it after, we correct that mistake and don't charge it.
Does that fee include updates of the deeds?
Uh,
Doing the documents for transfer that of assets into the trust.
So if somebody decides they want to do trust planning, at that point, then what we do is we then decide we're going to work on an hourly rate. And so then it's more just looking at how many, somebody could own land in multiple states. And so it's hard to just have a basic flat fee. So at that point, we kind of talk about what the cost would be. And because I think that's an important consideration when somebody is doing their estate plan, like, what is this going to cost me? I know that there are other firms around North Dakota that have a flat rate of like $9,000 to $12,000. And they give you a binder of documents when you walk out and they have them all recorded. But I just don't feel like, and I'm not speaking poorly of any of those firms. I feel like it's not fair to charge people for the time that they and resources of ours based on what that is instead of doing a flat fee.
You do a state planning or whatever.
Yes.
You change as time goes on, but you haven't passed away,
Yeah.
or are you stuck in that?
That is a great question. I tell people that all the time. You can change your will and your power of attorney. You can change it every single day of your life. Only once you no longer have like mental capacity to be making those decisions, you can make a change every single day. And we also do I didn't include it on here, but we also provide you with a personal property memorandum. So if there's like things that aren't cash or land that you want to gift to family members, like let's say tools, firearms, recipe boxes, quilts, jewelry, all of that, you can just write that on that memorandum. You don't have to re-sign your will every time. So we like to joke with our clients, like if you're ever kind of annoyed with one of your children, you'd be like, I'm at home rewriting my will. And it could just be like, who's gonna get this vehicle or boat or whatever else.
So you should still list all
No, I don't think so. If you do, like in your actual will, let's say you list every single object in your home in your will, but you've gotten rid of it during your lifetime, then we just treat it like you don't have it anymore. We don't go back to somebody and we say, oh, well, it's in the will, so it's supposed to go to this other person, so you should give it back to us so we can give it to the right. We don't do that. We just say that if you no longer own it at death, then it's void. We don't get that taken care of. Like you forgot. Oh, well, so then your will provides that your personal representative can decide how any like personal property items should be distributed, or sometimes if you want it just to go amongst your children, then your personal representative will just give among your surviving children or surviving children and grandchildren. So that's a question that we ask, how do you want that happen?
Only thing you can change.
Right. Once you have an irrevocable trust and everything has been recorded in the deeds and it's fine, we can't make any changes to that without a court order or without a trust protector, like attorney making all of the proper steps, which can be very expensive. Right, so the irrevocable trust or the life estate deeds are not generally something you can change, and that's why those have that 5-year look back protection.